subjects at the end of a long, hot summer that have somewhat more sex appeal than equity. But if equity doesn't have all the sex appeal of conflicts or constitutional law, for the purposes of the bar examination, it does have a particular appeal. One is you're going to get 4 questions approximately, never less than 3, and it's a very, very easy subject, and it's a great place to pick up points. So as such, needless to say, it has an appeal. Before we launch into the specifics, let's just sit down and see what it is we're talking about. Equity actually is not really a subject of substantive law in the same way that torts would be, the constitutional law would be, or conflicts would be. Actually, what it is it's, and would probably be more properly named, equitable remedies, and as such spans many of the areas of substantive law. For instance, we're going to be dealing with torts, we're going to be dealing with contracts, and all we're talking about within the areas of substantive law is what type of remedy is going to be applied. Nothing more, nothing less. If you think about it in this context, the approach to any answer that you're going to get in the bar examination is very, very easy to lay out, and once again, it's a great place to pick up points. All right, that brings us into the nature of equity. And there's a couple of basic questions we're going to talk about in, once again, outlining the specific course as a whole. And when we get to the specific areas, torts and contracts, you'll see these questions coming up again and again. Any time that you answer any question in the bar examination, you've got to answer it in terms of these questions that make up the nature of equity. For instance, equity is a remedy that will be used only where there is no adequate legal remedy. Once again, we're talking about a different type of remedy. This is the type of thing where you are compelling somebody to do something, where he has to perform an act or cease performing an act, whatever the case may be. This type of remedy will be brought into play by a court and will be utilized by a court only where the legal remedy is inadequate. You sit down and think about it then, if this is the type of remedy, the second question that arises is also obvious enough. Then that's the fact that you cannot compel a person to do anything unless you have personal jurisdiction over him. All right? There under that final axiom, equity acts upon the person. The third thing that you have to do in equity, and this is actually a historic rule if nothing else, is the fact that equity will only act where there is a property right to be protected. Last but not least, equity will only act where enforcement of the equitable decree can be assured by the court, at least to the court's satisfaction. They won't give equitable relief where they feel that it would be a fruitless thing to do so because they can in no way enforce it. Now, so much for the various little rules. You might note any time any of these rules are discussed in the bar examination, that after discussing the general rule, you can rest assured that the case is, and the statement should be made, that almost all jurisdictions, and specifically Illinois, are liberalizing their trend with respect to all of these things. Thus, for instance, the courts, and once again specifically Illinois, will go out of their way, if you're talking about equity applying only where a property right is present, to find a property right. The example is given in the outline, for instance, of the case of defamation. Well, the Illinois courts, for instance, have found the situation to be such that a person's job could be endangered by virtue of the defamatory statements, and as such will find a property right to be present in such a case. If you're talking about the enforcement of equitable degrees, once again, the courts, and specifically Illinois, are getting ever more liberal. They'll issue mandatory injunctions now. They'll find that routine acts can be supervised. All these things, incidentally, we'll go into in more detail when we start discussing the specific subjects under the outline. Similarly, with respect to equity only acting upon the person, you'll find as we go through the outline that equity will act today, and once again specifically in Illinois, where the court can otherwise ensure satisfaction to its own satisfaction, such as, for instance, in the case where they can act on the land in a quasi-in rem situation. All right, so what we're talking about then once again is the type of remedy, nothing more, nothing less. Now this type of remedy will vary according to the specific area that we're talking about. The first area we're going to talk about today is application of an equitable remedy to the substantive area of law of torts. Invariably, this is going to arise in an injunction situation. When you get a question on the bar examination, the very first sentence of any answer that you give in this area should lay out the tort that you're talking about. It should read something like, so and plaintiff in this case is seeking injunctive relief against the tort of nuisance or trespass or whatever the case may be. All right, now there's a couple of general statements that can be made about injunctive relief. One is you should note whether or not the injunction being sought is a mandatory or a negative injunction. A mandatory injunction being one where you ask the defendant to perform a positive act, a negative one being where you ask him to cease performing an act. We'll get into this later under enforcement. The second thing to do is note whether or not you're seeking a permanent or an interlocutory injunction. On a permanent injunction situation, needless to say, you have a full hearing on all the merits of the case, and the decision is final and binding. In an interlocutory or temporary injunction case, all you're asking is for injunctive relief pending the full hearing for the final injunction, and you might note that this type of injunction will be granted only where the facts really warrant it. There has to be a great showing of irreparable injury. Okay, now, once again, as I stated before, the first thing you do in any such question dealing with this is you lay out what the tort is. Now, I might mention that as the bar exam becomes increasingly sophisticated over the years, the bar examiners tend to go further afield in picking out the torts that they'll bring in. You can count, incidentally, on one question in your bar examination coming from this area that we're going to discuss right now, namely injunctive relief in a tort situation. Okay, now, still, nonetheless, even though they're going further afield, there are basic favorites of the bar examiners. Two of these favorites are those of nuisance and trespass, which will appear either alone or in conjunction with one another, and they usually appear together with a balance of hardship situation. But before we get into that, let's just discuss them generally. Obviously, you know what nuisance is. Nuisance is once again, we won't go into any of the torts such as this, into the substantive aspects of them, because I assume you know them. Similarly with respect to trespass. But as to how this will arise in a bar examination situation, let's take a look at question number 2. Find it somewhat more effective if you read it yourself. All right. 2 is one of those very easy questions I was talking about. Yet I happen to know the bar examiner that drafted this question and corrected it, and he informed me, and I can well believe it, that somewhere in the neighborhood of 60% of the students answering this question got only 50% of the credit. Reason is that most of them misread it, and it's too axiomatic to repeat, but particularly when you have only 18 minutes to read a question, make sure you read it carefully. Now, what happened in this question is, well, let's handle it first of all. The first of the two situations is that of Adams versus the metal worker. Now, if you're going to answer this on the bar examination, the way you answer it, once again, as I stated, your first sentence is, we're talking about here injunctive relief against the tortious conduct amounting to a nuisance. Sentence number 2, and once again, if I keep on repeating this, it's just because I want to drive the point home, because this, and I know this for a fact, because I know the bar examiners that work in this area, is the type of thing that's going to give you your extra points in that examination. Sentence number 2 is you talk about whether or not there's a property right present here. And you state that there is a property right, obviously enough under these facts. Sentence number 3 is you put down whether or not this could be compensated for by money damages. Obviously, in a nuisance situation, money damages aren't going to make him whole. Therefore, there'd be irreparable injury, the legal remedy is inadequate, and an equitable remedy should be applied. Then, and only then, do you get into discussing the facts as such. And here you, in talking about these facts, it would seem that the injunction was improperly denied, that the nuisance is of such a nature that the injunction should have been granted, and that equitable relief should have been given in this case. All right? So much for Adams versus the metal worker. Most of the people answering that in the examination more or less got that answer correct. What they did, however, in Adams versus the woodworker is exactly the same thing and handled it in exactly the same way. And as such, they misread the question. Because the second half of that question deals with the fact of whether or not a temporary injunction should be given. And as you'll remember, we just talked about it, a temporary injunction will be granted only in those situations where there's a great showing of irreparable injury. And those are the facts you have to play with then in that situation. The question asks for nothing more. Okay? Now, as I stated, most of the questions that you're going to come across when you're dealing with the torts of trespass or nuisance are going to involve the subsidiary question of balance of hardships. Most simply stated, this rule states that the court, wanting to apply equity equitably, is going to balance the hardships to make sure that there is no undue hardship worked upon the defendant if this decree is issued. And every so often, this defense will help bring the defendant out from under, and equitable relief will be denied even though the situation might otherwise call for it, i.e., even though there is a nuisance or there is a trespass present. You might note, once again, that the Illinois courts have been getting ever more liberal in construing all of the equitable applications, and one such area is here. Thus, for instance, there's an Illinois case, and the example setting it forth is on page 7. And this case had the following fact situation. There was a nuisance situation. And what it was is there was a factory that had been built, and the factory was emitting smoke and gaseous odors and what have you. Plaintiff brought an action and said this amounted to a nuisance. Factory came in and said, yes, we know, but there would be a balance of hardships argument here, and the hardship would just simply be too great on us. Well, the court really sort of bypassed whether or not the hardship would be too great on the defendant per se, but went out of its way to find that since the defendant employed so many people, and since the property interest of the plaintiff in his own land was not that terribly great, that it was the people that were employed by the defendant that they were really going to protect, and that they didn't want to have suffer from the hardship, insofar as if the injunction had been granted, the defendant would have literally had to close up shop. Now, you might note, incidentally, when you are answering any hardships question, look in the facts to see, and the facts will always specify, you can count on it, what the defendant's conduct was like. And remember that the balance of hardships argument, as a general rule, can be utilized by the defendant only in that situation where his conduct has not been willful. If his conduct has been willful, as a general rule, he will not be able to rely on the balance of hardships defense. Let's take a look at question number 10. Question number 10 sets forth the almost classic trespass, nuisance, balance of hardship situation. As I've stated, this is a constantly reoccurring bar examination question theme. As such, you should make it a point to know it. Once again, it's extremely easy to know and to master. But if you want to, once again, the thing that's going to separate the men from the boys in picking up points on the answer is how you set your question out. And once again here, you start out by stating you want injunctive relief, either with respect to a nuisance or to a trespass. You state whether or not there's a property right involved. You state whether or not the legal remedy would be inadequate. Then you discuss the facts. All right. Here, obviously, in both situations, we're dealing with balance of hardship questions. The first one, the trespass would appear to be minor enough, and the hardships, when balanced, would appear to be so onerous vis-a-vis the defendant that the defendant would probably prevail, even though equitable relief would otherwise apply because of the hardship that would be worked upon him. In the second situation, because of the nature of the nuisance, the hardships argument probably would not prevail, and in the relevant Illinois cases, which handle, if not the exact situation, analogous situations, this would appear to be the rule. You might note that most courts, and this includes the Illinois courts, are much more inclined to balance hardships in a trespass situation than in a genuine nuisance situation. All right, let's take a look at question number 7. Once again, is another basic question. After setting out your legal remedy and adequacy, property right, etc., you get into discussing the facts and the balance of hardship situation. You might note here, and it could be noted once again with respect to question 10 that we just handled, that when you talk about balance of hardships, you talk about the nature of the defendant's conduct. Now, in this case, the whole question revolves, and the whole answer revolves around the defendant's conduct. And so when you get to discussing the balance of hardships, you get down to discussing whether or not, under these facts, his negligence was not so gross as to amount to willful conduct, and if it was, he will not be able to rely on the balance of hardships line of defense. All right, now waste, which is the next area, for some unknown reason, has never appeared on the bar examination. I'm almost inclined to think that it won't. Once again, waste as a tort is something I'm sure you're familiar with. If it does arise in a bar examination context in the area of equity, I wouldn't be at all surprised to see it arise where a remainder man is suing the life tenant for ameliorate of waste. As you know, this is where something such as the example given here, such as a historic house, is about to be torn down, and where actually the property is even about to be improved as far as value goes. Whether or not the action will lie would depend on a great many factors. It's usually the type of thing where all you can do is play around with the facts. If it appears on the examination in an equity context, which is to say the tort waste, I believe it will arise in this area. You should make it a point that you know about ameliorate of waste. All right, defamation is something that has already appeared on the bar exam and is the type of thing that I would expect to see again. Take a look at question number 36. Actually, the answer to this we discussed before, and talking about the broad general area, or the dealing with the nature of equity, namely that of whether or not a property right is present. So when you're setting out your answer here, and you've already handled the type of tort we're talking about, you've handled whether or not the legal remedy is inadequate, you should discuss at some length, because that's what we're talking about here, whether or not a property right is involved. Once again, most courts, the trend is for them to be quite liberal. This includes Illinois. And in defamation situations where once upon a time they would not have found a property right present, they will today, because they'll hold that the person's job, livelihood, is in some way endangered by the defamatory statements. Needless to say, in light of the fact that our plaintiff here is also a public official, and the public as such would have a right to know about his conduct, constitutional problems would arise and should be discussed. All right? As a practical matter, the result here would be such that if the statements were made in good faith, the constitutional aspects would be such as to control and freedom of speech would prevail. If, however, the person making the defamatory statement, of course, knew that it was false, needless to say, he cannot rely on his constitutional grounds. All right? Invasion of the right of privacy is a tort that has not yet arisen in the bar examination. I wouldn't be at all surprised to see it there. If it does arise, once again, remember to focus in on the question of whether or not there is a property right present. And remember that the courts will stretch their decisions to find a property right where they deem it really a proper situation for equitable relief. Thus, if somebody is using a photograph of somebody else without their permission, the courts will even go so far as to say that the person who's the plaintiff has a property right in the photograph. There are, as a matter of fact, 2 decisions in other jurisdictions on precisely that fact situation that have so held. It's a bit torturous, the reasoning, but as I say, the courts, when they feel it's a proper situation for equity, will torture their reasoning. All right, the institution of wrongful judicial process. This is the situation, actually it's twofold. One is the situation where a suit is threatened to be brought or has in fact been instituted, and where the one party believes that it has been wrongfully brought and wants to have the equitable relief to stop this suit from going forward. If this arises on the bar examination, I can only think of one context in which it will arise, and that's the context of the example on page 3. And this is the type of thing where you have plaintiff and defendant in the jurisdiction of state X, but the action is being brought in state Y. And the question there is whether or not equity will act via an injunction to withhold a suit going forward in another jurisdiction. And the answer is, if the full merits of the case can be presented, and if the court is convinced of the fact that the process has been wrongfully instituted, albeit in another jurisdiction, they will grant equitable relief as long as both the plaintiff and defendant are specifically the defendant, is within their jurisdiction. This once again gets down to the question of enforcement of an equitable decree. If you remember, we keep on talking about the basic questions under the nature of equity. This is really an enforcement question. As long as the court believes that it is in a position to enforce their injunction, they'll grant it. And in this case, since the defendant is within their jurisdiction, they'll give injunctive relief where proper, even though the suit that's being talked about is in another jurisdiction. The second category under this tort is that of prior fraudulently obtained judgments. This is the type of thing that I would be inclined to say probably would not arise in a bar examination, except that it already has. The basic rule is that, and the one you should look at is to see whether or not the fraud was intrinsic or extrinsic. Those are the key words. If it was intrinsic, something that could have been exposed at the prior trial, such as perjury, the general rule is that the court of equity will not grant relief. If it was extrinsic, something that could not have been exposed at the time, such as the bribing of the judge, then the court will grant relief. Let's take a look at question number 8. Question number 8. As you see, this sets out a fact situation dealing with fraudulently obtained judgments. It also sets forth the two possibilities. The first situation is that of perjury at the former trial. As unhappy as the result is, and Illinois would appear to accord with this, equity will not grant relief since it will state that the perjury could have been exposed at the prior trial. This reasoning is generally spurious in the decisions I've seen, but so be it, that happens to be the rule. In the second situation, there might be a far better claim that the fraud perpetrated was extrinsic, and as such, that this judgment, enforcement of this judgment, is a fit subject of equitable relief. Query whether or not the defendant, in this case Adams, might not claim that Brown should have showed up at court in any event, and there he could have exposed the wrong, and that as such it should be construed as intrinsic fraud. I'd raise the query, since it is an equity court, I think they might look with some suspicion on any such defense by Adams. All right, now if there's, the next tort we're getting to is that of unfair competition. And I'd say, once again, you're going to get, you can count on it, you're going to get one question on the bar examination from the area of injunctive relief related to torts. And I'd say that the bar examiners, as far as their favorites go, unfair competition is running neck and neck with trespass and nuisance. In light, once again, of the increasing tendency on the part of the bar examiners to get ever more sophisticated, unfair competition almost seems to be a better bet. It seems also to be a better bet for the very simple reason that there's always new case law being made in this area, and as such it provides a much more fertile field for bar examination questions. There's a variety of things that fall under the broad umbrella of unfair competition. For bar examination purposes, probably as important an area as any other is that of the use of a competitor's trade secrets. This is, once again, this is also one of these constantly arising subjects of bar examination questions. When you see a trade secret issue raised, the first thing you should discuss in answering your bar examination question is that of whether or not what is involved is, in fact, a trade secret. You might note that Illinois, specifically in a case called Schulenberg versus Signatrol, which we'll discuss later, tends to be very liberal in holding that there is a trade secret. And as a matter of fact, Illinois, if the other facts show that equitable relief should be granted, almost invariably will find it to be a trade secret, whatever it may be. Okay? The second thing is you should look to see how the trade secret was taken. You might note once again that Illinois has been very liberal in this. Once again, the Schulenberg case is a prime example. If it has been memorized, there's a split of authority, but Illinois is with the liberal trend, which states that even if it was memorized, this will be a sufficient taking. This is very important because you have invariably the situation where somebody has been in the employee of a company for a number of years and leaves it and goes elsewhere with this knowledge and claims, oh hell, that wasn't a trade secret I took, that was just something I picked up through my experience of working there. Well, Illinois will construe this fairly harshly, and if they find out there was any sort of fiduciary relationship or any situation where they think that that person really shouldn't have left the employee of the former employer and utilizes information in the way he did, they'll hold that it was memorized and that this was a sufficient taking of a trade secret. All right. You might also note when you're answering this question, look to see whether or not it was an employer-employee situation. It usually is in the bar examination. As such, you might raise the prior fiduciary relationship of the two parties. You might also note in this situation that it is not necessary that there have been a prior specific contractual clause. Just the prior relationship itself will be sufficient. I mean, Illinois has held such in a number of decisions, most recently in a case called House of Vision versus Hyann, which was a 1965 decision. All right, let's take a look at question number 16. Question number 16 obviously touches upon a variety of issues, not merely the trade secret issue. Actually, both parts A and B are trade secret questions. We're going to get to discussing part A in a trade secret context later on when we get to talking about personal service contracts and specific performance. We'll come back to this question. On part B, this is the straightforward trade secret question. The first thing you do, once again, in your answering of the bar examination question is you should set forth the fact that this is a trade secret, and then you move on to talk about the fact that it has been wrongfully taken. Remember, Illinois holds that memorization is sufficient. Incidentally, in setting up your facts here to prove this is a trade secret, you might use for support of such an argument the fact that he went through the trouble to memorize it would indicate that it was a trade secret and not otherwise readily obtainable. All right. The next large area within the law of unfair competition. Incidentally, before leaving that, I might mention that when you talk about wrongful use of a trade secret, or let's just say use of a trade secret wrongfully taken, that the plaintiff may go after a number of people. He may, of course, go after the person that took it wrongfully. He may also direct his action towards the person that's using it. All right? Trademarks and trade names. Also something that comes up in the bar examination fairly often, most specifically in bar examination context as a trade name, but the same reason is applicable to both. The first thing you want to do, specifically with respect to trademarks, is you want to see whether or not you have a valid trademark in the first instance. Both trademarks and trade names, as a general rule, are affixed to either goods or services, and as such they are to identify, are used to identify the source of such good or service. Keeping that in mind, everything else will make sense and be easily understood. Obviously, if you're going to indicate source, you have to have something that is not subject to being applied to a great many sources, or where the source would be in doubt. Thus, for instance, generic terms will not identify source. Descriptive terms won't identify source. Personal names won't identify source. For instance, there are a million Smiths, and as such, putting Smith on something as a trademark will not necessarily identify source. Geographical names, calling something Chicago toothpaste, will not necessarily identify source. Now, good common sense is going to tell you that in certain situations there will be exceptions to this, and these situations are generally those where the secondary meaning exception comes into play. And what this is a rule developed in the body of trademark and trade name law that says that if a specific name, this does not incidentally apply to generic terms, it does apply to geographical names, it does apply to personal names, and you might incidentally, under the secondary meaning exception, add a little insert saying it will also apply to descriptive terms. And this rule is basically that if this name has been attached to these goods or these services for a long enough period of time so as to become associated in the public's mind with these specific goods or services, that the secondary meaning exception will come into play and it will be held to be a valid trademark. All right? Now, in any discussion of a trademark or trade name question on the bar examination, there's one thing that you should get in. As a matter of fact, not only would it be nice for a couple of extra points, but it's become so relevant in present-day trademark and trade name law that I'd almost go so far as to say it's a necessary inclusion in any answer. And this is the fact of what is the basis of trademark or trade name protection. Now, historically, the basis has always been as follows. The courts have always said, well, the person that owns the trademark or the trade name has spent considerable time, energy, and money in developing it. As such, he has a property right in this trademark or trade name, and we're not going to allow the infringer to benefit by trying to impinge upon the other person's goodwill. Historically, this was the reason that the courts gave protection, and this was the only reason. And as such, they were much more inclined to strictly draw the boundaries of where protection would or would not be granted. Today, however, there not only is a second reason that's been added, but actually it has become more important, and as such, the courts are far more liberal in granting protection. And this is the reason of the court's desire to protect the public. Once again, bear in mind, trademarks and trade names identify source. And the public comes to rely upon a trademark or a trade name as being representative of quality, of a certain quality, whatever it may be. So that when a housewife goes into a supermarket and she buys an orange wrapped cereal box saying Wheaties, she's learned to rely upon this trademark, this trade name, meaning something to her. And she learns that when she opens that package up and eats it, she expects a certain thing. This is true of anything, all right? The courts will go out of their way to protect the consumers today from being confused as to source, and as such, their opinions have gotten far more liberal. All right, let's take a look at question number 4. Question number 4, insofar as it relates to the trade name issue, is a relatively straightforward question and can easily be answered. The first thing you do is you set forth that this is a trade name. You should set forth that it's a trade name entitled to protection, that it serves to designate the source, and that the second trade name being used will work upon lessening or will infringe upon the prior trade name owner's goodwill. As such, you're going to protect him, and as such, you're also going to protect the public from being confused. You might also mention in any analysis of that question, which you should, as a matter of fact, in any trademark or trade name question, whether or not it appears that the conduct of the infringer was willful. In this case, it would appear obviously to be the case. Let's take a look at question number 6. Question number 6 clearly focuses on the very thing we've just been talking about. Here we have 2 hotels, the Hotel Oregon and the Hotel Scott. The Hotel Scott being the subsequent the Hotel Oregon being the previous incarnation of the Hotel Scott. This answer should probably be handled in the following way. The first question that arises is that of whether or not the trade name owner is even entitled to protection. After all, he's abandoned this name. I query whether or not somebody is entitled to protection for a name they've abandoned. Well, the answer to that is probably yes, they are entitled to protection for a limited period of time. But the question here sets forth a rather long period of time. So here we have the classic situation of where the court, given that and nothing more, and had this decision been answered 20 years ago, the result probably would have been no protection because this trade name has been abandoned. However, today, as I've stated, the courts are more interested in protecting the public. And particularly since the first of the two defendant hotels was a flea bag type of operation, and since the public might have been confused and might have gone to that hotel mistakenly thinking it was the other one, and since the court is interested in protecting the public, the answer here is that they probably will hold that there has been an infringement. But before leaving this question, there's something else you should note, and this is a question that also raises, and we'll handle it right now, the classic defense of laches, which is one of the basic equitable defenses. And laches is akin to a statute of limitations, and although there's no set period of time, the claim of the defendant who wants to rely on this defense is, there's been such a lapse of time now that I've relied to my detriment on using this name, or I've whatever it may be, in any equitable situation, and that to hold as you are would be inequitable. And this might be a classic laches situation, since here, over a period of many years, the defendant has invested a substantial amount of time and money in promoting his hotels now under this new name. And he might have a valid claim that had the first hotel wanted to complain, all well and good, but it should have done so long ago. As between the two parties, this defense would unquestionably prevail under this factual situation. Once again, however, I think I would mention the concern of the courts in protecting the public. And as I say, courts today, and specifically the Illinois courts, will go out of their way. And once again, if you see a trade name or trademark question in the bar examination, it most likely will involve this issue. If not directly, such as this question, certainly indirectly, and that should be mentioned, the protection of the public. All right. The related areas to trademarks are, of course, the areas of copyright and patent protection. Patent protection is something that I doubt as such will arise on the bar examination. Copyright protection, perhaps. You might note in studying this for bar examination purposes and in analyzing any question that there's a basic difference between trademarks and trade names and copyrights and patents. And that's the fact that trademarks and trade names, you may have a valid trademark or a valid trade name, even though it has not been registered. And as a matter of fact, you acquire your rights, and your rights become stronger the more you use this name. Here, once again, we're identifying source, but it's also source in a sense of protecting the public. Now, in a copyright or patent situation, there is no such great interest in protecting the public, and thus the common law rule that prevails today is that you have protection of your common law copyright or patent only to the extent that you may make the first introduction of this to the public. Once it's been introduced, you have no rights in it whatsoever unless you've gotten them under the federal statutes. You have no common law rights in them anymore. As I say, a patent situation is something I doubt will appear in the bar examination. It's very possible, and there have been questions in the past dealing with the copyright situation. And they invariably deal with the thing I've just talked about, namely that of the right of the person who has created this work to make the first introduction. And then the next question is, what constitutes an introduction? And invariably this arises in a factual context such as a professor who gives lectures, this type of thing. And a student busily copies this down as his notes, walks off, takes the whole thing down in shorthand, and sort of beats the professor to the punch. The professor comes in and claims, no, that was a book I was writing, I sort of tested out on my students in the lectures, but that's really my work, and I had not yet made the first introduction to the public so as to lose my common law copyright. The student claims, well, you know, to hell with that. You gave it in your lectures. That was an introduction. That was sufficient. Well, courts, once again, these are equity courts. They'll go out of their way to come up with the proper remedy in situations that have arisen such as that. The answer is that something like a lecture will not be construed sufficient for purposes of a first introduction. All right, now in the related area, usually generally related to patents, and we'll handle this and then we'll take our break, is the area of the right to imitate. And this is an area that is extremely important, particularly important in Illinois, but really important everywhere, and particularly important for bar examination purposes, and this is something you had better note. It's specifically important in Illinois because there have been two extremely famous Supreme Court cases on this, which have been the subject, and I exaggerate not, of at least 100 law review articles. They're of particular note to us because they went up through the Seventh Circuit. They were Illinois decisions, and the entire law that was applied was the entire body of Illinois law relating to this. And these are the famous companion cases of Sears versus Stifel Lamp and Comco Corporation versus Daybright Lighting. Basically, and simply put, the facts of these cases were as follows. Let's take the Sears case. The Comco case is, for all practical purposes, identical. Stifel Lamp Corporation came out with, and were the first people to come out with, the pole lamp that everybody now knows, stretching from floor to ceiling and having a couple of lights along the way. They got a patent on it. Sears came out, manufactured the identical lamp, and started marketing it at a substantially reduced price. Comco Corporation, or pardon me, Stifel Corporation came in and said, look, you can't do that. And they relied on their patent. So the first thing that happened is the patent was held invalid. That's irrelevant for our purposes, really. What is then important is the right to imitate, because that was the question that was then raised. And then Stifel turned around and said, well, look, even if the patent's invalid, you cannot come in, take a creative product of ours, and imitate it 100% and market it. And you might note here, incidentally, that Sears admitted offhand that they had taken the Stifel lamp and copied it. They just claimed they had a right to do it. And the court held as follows: yes, you have a right to imitate. As such, they overruled prior Illinois law, and this is the law today. Now, this brought with it several problems, and there's been a fair amount of case law since, so you should note two factual situations, and if it arises in the bar examination, it's going to arise in this context. I expect to see it in the bar examination. I would not be at all surprised if it showed up in the bar examination this time. Context number one is that you may indeed imitate, but you can only imitate if at the same time you're not working to deceive the public. So look to see whether or not there's a related trademark that's being used. I mean, if it's Stifel lamps, if Sears had marketed them and put on there something like Stoffel, or had there been an extremely unusual color like shocking pink, which was used really more by way of identification rather than by way of functional design, and all the other lamps manufactured by the competitor were manufactured in this offbeat color, that might be intended to deceive the public as to source. As such, there will be protection granted to the first owner. Now, there's a second very interesting situation. This is the thing we talked about before when I said we get back to question 16. It's the Illinois case of Schulenberg versus Signatrol. It's a landmark decision, and it has not yet appeared in the bar examination. I expect it. The situation was as follows. The defendant worked for plaintiff company. While working for plaintiff company, he learned all about the mechanisms of the product the plaintiff was marking that was the backbone of its success. Defendant then leaves plaintiff company, goes off, sets up his own company, and starts to manufacture the identical product. They wind up in court, and the defendant raises the following defense. He says, look, he says, first of all, your product was in the market. Anybody could have bought it, could have taken it apart and seen how it was made. Indeed, as a matter of fact, you even had diagrams of the things that explain this in large part that you were giving out to your sales personnel and to your distributors. Therefore, I'm protected, since there's no patent, under the Sears and Compco doctrine. After all I did was copy it. And the court held as follows. They said, no, we're not going to allow that. And the answer is, had you been an unrelated third party and had you copied that, that would have been all right. Sears and Compco would have protected you. However, in this case, you were previously an employee of the company, and even though you could have copied it in the way that you maintain you could have, and even though we agree to that, nonetheless, in this situation, there is a fiduciary responsibility that you owed to your former employer, and we're not going to let you get away with it. As such, they granted protection. As I say, I expect to see that in the bar examination. You should really note that factual situation. Let's take a break. A clarification on the material that we just covered. A fairly valid question was asked during the break here, and I think it's an extra point you might note, and that's in dealing with trademark and trade name protection, there might also be a geographical ambit of that protection. So that, for instance, if you have a Royal Club in Chicago and a Club Royale in Springfield, they might hold that the geographical ambit of protection is not sufficient to uphold an infringement action. So you might note this incidentally in any question. Look to see whether or not they specify a distance in there. The such and such a club was opened up several blocks away from the other one. Was it opened up on the other side of town? Was it opened up in another city? All right. Now the next questions as set forth in your outline, and these are things we've discussed all the way along. It deals once again with the very basic nature of equity. Their questions have got to be answered. Once again, things like, is the legal remedy inadequate? All right, you might note incidentally as a general rule that the legal remedy is invariably inadequate where land is involved. They may come out from under by torturing their reasoning or by finding a balance of hardships argument should prevail. But as far as the straight question of adequacy of legal remedy, land is always inadequate. All right, now the legal remedy, when we talk about legal remedy, in fact, we're talking about, with few exceptions, one thing and one thing alone. We're talking about damages. So obviously you have to look to the nature of the damages. Now, if damages are speculative, the legal remedy is inadequate. Similarly, if the defendant's insolvent, obviously the legal remedy is going to be inadequate. Two other situations arise. One is that, of course, of irreparable injury. Legal remedy is inadequate. And last but not least is a situation, and it has appeared in the bar examination, and we'll cover it later in that question, which is that of multiplicity of actions. And this is the thing that says, even though your legal remedy is in fact adequate, if you have to keep on bringing this action again and again and again, we're going to hold it inadequate for purposes of this particular result, and equitable relief will be granted. All right, your outline then moves on, for instance, to is a property right present. We've talked about that, and rather than kill a dead horse, just let me once again make the comment, make sure that that sentence is in your answer. All right, is enforcement feasible? This is something, once again, that also keeps on rising on bar examinations. We mentioned before when we started out talking about injunctions that there are two types of equitable decrees that are generally granted in the area of injunctive relief. One is a mandatory injunction, where we're compelling somebody to do something. Mandatory injunction, we're compelling him to go out and perform certain acts. Negative injunction is the type of thing where you just say, stop performing those acts, stop doing what you're doing. Now you might note historically equity courts would only give negative injunctions, they would not give mandatory injunctions. If you see a situation in the bar examination where the plaintiff is asking for a mandatory injunction, you should state this. You should state that historically equity courts didn't give it, but there's been a trend towards liberalizing this, specifically in Illinois, and that courts, equity courts today, will issue mandatory injunctions where they are assured in their own mind that performance can be guaranteed and where they will, where they can supervise the acts. Generally, what we're talking about here are rather routine acts, the type of thing that can be easily supervised. We're talking about somebody painting a picture. That's not a routine act, and an equity court will not issue a mandatory injunction because they cannot adequately supervise it. Similarly, with respect to things such as enforcement of a decree where you have to have an out-of-state act. Once again, we've already talked about this in one context before, where we talked about the situation where somebody seeks equitable relief in that case where an action has been wrongfully instituted in another jurisdiction. Once again, if the court has jurisdiction over the defendant and thinks that they can enforce it because they have this jurisdiction and control over him, they'll go ahead and do this. They wouldn't have done this in the past. Once again, the basic rule is equity courts are becoming ever more liberal. All right? Balance of harshness, we've talked about. Once again, that arises in nuisance and trespass situations invariably. Last but not least is the case of, does the defendant have any defenses? All right, we've talked about latches. We're talking here basically about equitable defenses as compared to the defenses of a substantive nature, such as consent, let's say, as a tort defense. All right, latches we've talked about. Remember that latches may be raised, but they may only be raised. The lapse of time in and of itself is not sufficient. Latches may be raised only where this lapse of time has been prejudicial to the defendant. Those are the words, note them. Once again, in our Hotel Oregon case, the defendant might claim that he's expended a considerable amount of money and time in promoting the Hotel Oregon with respect to his own business. Therefore, this time span has been prejudicial to him, and he should be allowed to use this defense. The second basic equitable defense that will consistently arise in the bar examination is that of unclean hands. You might note that unclean hands as a defense can be raised only in that situation where it relates to the same transaction. Now, if you remember, we read a question a while back for another issue. It was the Club Royal one, and this was the question where the first nightclub, the one that was complaining because of trade name infringement, was allowing in minors. All right, now, if the defendant here seeks to rely on this defense and claims, well, hell, that guy's allowing in minors, unclean hands, that's my defense, the action shouldn't lie. The answer here is he will not prevail, and this incidentally should be raised. If you, in that question, this should have been raised and discussed in answering it. He will not prevail for the simple reason that the unclean hands conduct did not relate to the transaction in question, namely that of the trade name issue or the performer that had gone over. Okay? Injunctive relief against criminal conduct. You might note here, just as a general rule, that equity courts will not grant equitable relief in the case of a crime because they believe that there should be a full hearing due to constitutional grounds. We had, once again, in an earlier question, the fact situation where a lottery was being run by this one club. Well, the lottery cannot be enjoined if it's against a criminal statute. There has to be a full hearing by the court on this matter in a criminal context, criminal procedures being applied. All right, so much for torts. Once again, remember, equity is not an area of substantive law. It's just the remedy we're talking about, an application of a certain remedy acting upon the person and compelling him to do something. Now, we've seen this so far in the substantive area of torts, and it's compelling a person to refrain from tortious activity. Now we're moving over to the substantive area of contracts. And this is the other big area for bar examination purposes. Within the area of contracts, the favorite of the bar examiners, and once again, given the situation where you're going to get 3 to 4 questions, you can count on 1 question in your bar examination being in the area of specific performance. What we're talking about here is, once again, it's the remedy, and the remedy here is you're compelling one of the parties to a contract to abide by his agreement and carry out the terms of that contract. Okay? If you're going to, in setting up your answer for bar examination purposes, you should mention some of the substantive aspects. Substantive aspect number 1 is we're talking about specific performance of a contract. Does a valid contract exist? All right? Your first sentence in a specific performance question should say, A is seeking specific performance of his contract with B. A valid contract would appear to exist under these facts. Sentence number 2. Sentence number 3, it would appear that all conditions, contractual conditions, have been fulfilled. Let's talk about that now. There are 2 types of conditions that will arise on the bar examination. One is the condition precedent of time being of the essence. Now this periodically arises in the bar examination. You should note it. The first thing you should note about it is, for it to even arise in the first instance as an issue, there has to be, and the Illinois courts so hold, an express provision in the contract. Absent the express provision, no time of the essence problem. All right? Now, as to how equity courts will construe this, there's a fine old equitable axiom or maxim, which is equity abhors forfeitures. So as a general rule, in discussing any fact situation where a contract has a time of the essence clause, you should mention that equity courts will go out of their way to liberally construe it and to find a waiver of it, or to help the person that would otherwise be in forfeiture out from under. All right, now a waiver, of course, can arise in situations such as there is a time of the essence clause, and it says you have to pay on the 30th of every month. And the defendant is always paying it on the 5th of the next month. But he's been doing this for a year now, and the plaintiff has always accepted payment 5 days late. Well, when it happens in the 13th month, the plaintiff cannot now be heard to come in and complain. What will happen is the court will say, by your actions in the past, you've waived the right to stick by the terms of this clause, at least insofar as the time gap here is only 5 days. Let's take a look at question number 21. #21 is a fairly straightforward time of the essence question. We won't go into any great detail. You just might note that in any analysis of this on the bar examination, you should mention the fact that there is a specific time of the essence clause in the contract and that this is necessary in Illinois. You should also mention that these will be, where they are specifically included, they'll be fairly strictly construed, although the courts, once again, if a forfeiture is to be worked by it, will go out of their way to liberally construe them. In this case, a forfeiture would arise. However, the amount of the forfeiture is rather minor and should have been expected under this particular factual situation. As such, in this situation, the time of the essence clause will be upheld. Now, if the amount involved were $5,000 instead of $500, the court might have been leaned a little bit further backwards in order to come up with a different result. Okay, so much for condition precedence. There's a condition which always arises in the bar examination, which might be construed both as a condition precedent and condition concurrent, and that's the delivery of the object of the contract, specifically here with respect to contracts involving real estate, either with marketable title or in condition, such as was originally bargained for. Now, what happens in that situation where the vendor cannot meet this condition, i.e. where there's a flaw in marketable title or where the property is in damaged state, either subsequent to or in any other way where it was not agreed upon by the parties. In other words, where the damage was hidden before and is first discovered subsequently. Well, this is a typical specific performance with abatement situation. And basically the rule is that specific performance will be granted, but there will be an abatement, which is to say a readjustment in the purchase price. All right, now there are two situations, and you should note them, and when you see this in the on the bar examination, and this arises all the time, this situation, note to see who it is that, question number one is, who is it that is asking for specific performance? Is it the vendor or the vendee? Question number two is, how great is the defect, i.e. how large would the abatement have to be? If it's the vendor asking for specific performance with abatement, he may get it, but he may get it only where the defect is minor. He cannot force a bad deal on the vendee. In other words, where there's a great change in the value of the property by virtue of the defect. Where the vendee is bringing specific performance, he can take whatever kind of bad deal he wants, and he can always get it with a corresponding abatement in the purchase price. All right? Let's look at question number 15. Number 15 is obviously the basic specific performance with abatement situation. Once again, this is a gift question on the bar examination. Somebody should get full credit. Remember, in your analysis, you set out two things. Number one is... Will you hold on for 1 second, please? Apparently we're having some mechanical troubles. From the back room, hear me now? Is this coming through into the back? All right, gentlemen, let's get rolling. Question number 15. Once again, as I stated, this is pretty much of a gift question. As far as I'm concerned, it's very easy to get full credit on this. In setting up your answer for bar examination purposes, you ask the two questions we talked about. Number one is, who's bringing the suit? In this case, it's the vendee. Question number two is, how great is the defect? And here, in this case, the defect is actually fairly substantial, but since it's the vendee that is bringing the suit, the vendor may not be heard to complain, and the vendee will always get specific performance with a corresponding abatement in the purchase price. All right, let's take a look at question number 29. Right, question 29. Actually, question 29 has been the subject of a fair number of cases in Illinois. The only result that can be drawn, or conclusions that can be drawn from these cases, is that they appear to be inconsistent. Basically, the difference in question 29 from question 15 that we just handled, and the thing that has to be discussed on the bar, incidentally, this was another question that was greatly misread by a great percentage of the people in the bar examination, who went ahead and handled it as a straight, specific performance with abatement situation relating to a contract. Well, so far so good, except that this question involves an option situation. And the defect that would be the subject of any abatement arose after the granting of the option, but before the option had been exercised. Now, the obvious defense here is, look at the contract as such first comes into being when the option's exercised. You have a given price for the thing. If you want to exercise your option at a later time for that price, you know what you're getting, and you can't be heard to complain and get an abatement in the purchase price. Well, probably the rule in Illinois today is that that won't hold, and what will happen is that they'll go back to the time that the option was given in determining what would be the fair purchase price. They'll allow the vendee to exercise his option at a later date, and they will allow him to get an abatement in the purchase price. The bar examiner helped you get around some of the nebulous decisions that have come down in Illinois here by specifying that insurance money proceeds had even been collected by the vendor. This helps a court of equity come a lot further down the road in coming up with an equitable decision. Once again, though, this is a classic example, like our metal worker, woodworker question, which was the first one we handled, of why you've got to be careful when you only have 18 minutes in reading these questions. All right, once again, as we go through the outline here, we're going to see the same questions arise again and again and again. These are questions you've got to get in your mind and have really at your fingertips, so that when you answer and you analyze any equity question, once again, you're going to get a minimum of 3 and most likely 4 of them, that you can spew these things out. The next thing is adequacy of the legal remedy. That's got to be on almost any question you answer in this area. All right, here, in a specific performance context, there are several things that arise, and one is the legal remedy will be considered inadequate where the thing bargained for is rare or unique. All right, now, the general rule is that land is rare and unique, irrespective of whether or not you could get adjoining parcels of land that appear to be identical. I don't care if it's a little piece of land in the middle of right in the center of a desert that's 100 miles square. That particular piece of land is considered by equity courts to always be unique. All right, and as such, one always has, for instance, a property right in the land too. Now, what happens, here's the type of thing that might arise in a bar examination situation, and this is the type of thing of, obviously then, the buyer can get specific performance because the land is unique. The seller, of course, since he's only getting money, would invariably be deemed to have an adequate remedy at law for money damages equal to the amount of the purchase price. And as such, specific performance will be denied to him. Now, what will happen, and this is really it's a matter of form more than anything else, is they'll allow the seller to get specific performance in certain situations, even though the result is the same, obviously. Specific performance in this case amounts to money damages, but they'll use the specific performance vehicle where the contract has been performed in large part, such as the defendant coming on the land, taking possession, etc. All right? Personal property. Once again, it's the same sort of thing. Look, if you have a contract for specific performance or a claim for specific performance of a contract for the sale of personal property, you've got to mention whether or not that property is unique. Invariably, if you get the question on a bar examination, that's what they're going to ask for anyway, and they'll set the facts up that way. What makes something unique? Well, it could be a great variety of things that make it unique. It could have sentimental value to the individual. Thus, even though you could go out and buy the identical vase anywhere else, this particular vase has been in the family for 3 generations. It might be something that's extremely rare. A Rembrandt painting is obviously unique. It might be something that is not at all unique, but is rendered unique by given circumstances at the time. The example in the outline is that of steel during a steel strike. All right, a personal services contract. We'll handle this later, but you might note, even in the context of whether or not a negative covenant will be enforced, if you see a personal services contract, be sure and put in your answer in that bar examination a sentence down as to whether or not the services required are unique. Invariably, your questions will set it up this way. This is true of specific performance of anything. It's of any contract. It's true of a contract to make a testamentary disposition or to execute mutual wills as well. Look to see whether or not the subject matter is unique. Once again, the same other questions arise, and an inadequacy of legal remedy here is arise with respect to torts. That's the insolvency of the defendant. That's whether or not damages would be speculative. That's whether or not multiple suits would be necessary. To show you how this might arise on the bar examination, in what context, Let's take a look at question number 1. Question number 1 is really a question that revolves around nothing more than the question of whether or not the legal remedy is adequate. And this is the tact any analysis would have to take. The answer here is obviously the union could go in and make a determination as to what money damages should be. Therefore, under normal circumstances, the legal remedy would be adequate, i.e. money damages would be adequate. In this case, however, the court is going to apply specific performance, and they're going to do it on inadequacy of the legal remedy, and they're going to hold the legal remedy to be inadequate because under this given set of facts, they're not going to require the plaintiff to keep on coming in court every time there's a payday to get their money. So they're going to decree specific performance. That's question number 1. Question number 2 is you might note that in order to do this, they have to issue a certain type of injunction, and that's the case. They have to issue a mandatory injunction saying pay those damages over, or pardon me, pay the dues over every time. Since this is the type of act that can be easily supervised, in other words, it's very easy to determine whether or not the dues have in fact been paid over, the court will issue this mandatory type of injunction. You might note, incidentally, this is also the type of situation where a lot of courts, in trying to torture their reasoning but wind up at the same liberalizing trend, will go out of their way to not issue a mandatory injunction but couch it in negative terms so as to reach the same result. Here, for instance, rather than say pay the money over every payday, they could couch the injunction in terms of don't withhold the monies every payday. Enforcement, however, as a practical matter, would be the same under either decree. And as such, most courts, and including the Illinois courts, would issue a mandatory injunction today. And that, of course, brings us into the area of whether or not enforcement is feasible. The feasibility of enforcement contracts, or pardon me, of contracts for the sale of land is the type of thing that one can anticipate seeing on the bar every couple of years. There was one a couple of years ago. There hasn't been one since. I expect to see one in the near future. If you have a land sale contract and specific performance is sought, look to see, and actually the facts will usually be spelled out for you, what is before the court. Actually, what I'm talking about here is the question of look to see whether or not the plaintiff's before the court, the defendant's before the court, and the land's before the court. Now, if both parties and the land is before the court, there's no problem. Obviously, enforcement can be had. If the seller is before the court and the land's before the court, obviously no problem. The court can take an action. Now, what happens if you have the buyer before the court, the land is in the jurisdiction, but the seller is outside of the court? Now, as we talked about in the beginning in discussing the nature of equity, we talked about it, just once again, you're compelling somebody to do something. You're talking about then in personam jurisdiction. Well, how can you compel a seller to convey land if you do not have jurisdiction over him? Well, originally, the equity court said we can't, enforcement's not feasible, so we won't. And the case was dropped. Today, however, where the land is in front of the court and in Illinois by statute, the court will act. What they'll do is they'll take quasi in rem jurisdiction and they'll convey the land and sort of to hell with the seller. Let's take a look at question number 23. There's no need to even sit down and really go into any great analysis of question 23. We've just discussed it. The answer here obviously is yes, and specifically in Illinois, and you should mention that if this were to arise, you could mention and should mention that Illinois has such a statute. The liberalizing trend is that equity will exercise quasi in rem jurisdiction. In answering this for bar examination purposes, you should mention the history of it. should say that, you know, the whole bit on equity acts in personam, has acted in personam historically. That's because of the nature of the remedy, et cetera, et cetera. Now, as I've stated, I expect to see this type of question arise on the bar examination again. I don't necessarily expect to see it, however, with respect to any of the first three we've talked about. I expect to see the question arise in the bar examination any day now of the situation that's set forth in D here, which is that of where both parties are before the court, but the ray is outside of the jurisdiction. And the answer here is what will happen. Well, once again, this is what we've talked about in other contexts. For instance, we talked about this in the context of where both parties were before the court and there was a wrongfully instituted process in another jurisdiction. The answer here is that the court will exercise jurisdiction, they will find it to be enforceable, and they'll force the seller to convey. All right? The next area that we get to is that of a contract for personal services. Now, you might note that this, once again, is a favorite of the bar examiners. And this comes up all the time in the bar examination. You better know it. If you see it, the way to answer any question is the first thing you say is as follows, that a court of equity will not grant specific performance for a personal services contract. You may not have specific performance. The reason being that this amounts to involuntary servitude, and thus the equity courts just keep their hands off. That's got to be paragraph number 1 if you want full credit in any analysis. There is no specific performance of a personal service contract. All right, the second thing, though, and it's invariably involved in any question, is that of there being a negative covenant not to compete in the same contract. Several points, and note them, and make sure you know them because they all have to be raised in answering any bar examination question. Number 1 is, and we talked about this before, you first have to discuss the nature of the services. Are they unique? If they're not unique, there's the same sort of thing as a unique chattel or real estate being considered unique. If the services are not unique, the negative covenant will not be enforced. Now, invariably in your bar examination question facts, they're going to set you up with somebody whose services are unique. You want full credit, you better mention that those services are unique. That's number 1. Number 2 is you've got to note, and specifically in Illinois, for this covenant to be enforced, specifically enforced, it has to be expressly included in the contract. It will not be implied. Now, your bar examiner always raises this issue. When we go over the questions, you'll see how they do it, and we'll discuss it at that time. But you have to make that point in your answer of a bar examination question. All right, let's take a look at question number 4. Once again, it's a basic question. It's very easily answered. We're talking now, of course, obviously that aspect where we're dealing with the performer. Very easy to answer, but it has to be set out in approximately the way I just talked about. Number 1, you'll see the bar examiners mention the fact that contract has a year to run. Your first couple of sentences deal with the fact that even though it has a year to run, there is no specific performance of that contract, equity won't touch it, involuntary servitude. Question, your second point to be raised is the services are obviously unique, and thus any negative covenant contained in the contract would be the proper subject for specific performance, unique services. The third thing is, however, in Illinois and in a great many jurisdictions, this covenant will only be enforced where and only where there is an express covenant. Now, this question here, and note it because every question I've seen on the old bar exams in this area, and they come up all the time, has never set out the fact that there's an express provision, and yet almost every one of them uses the same word to indicate it, and that's the word of so-and-so agreed to work exclusively You might incidentally, for purposes of review, even underline that word so that it rings a bell when you're going through. Invariably, they use the word so-and-so agreed to work exclusively for somebody else. From there, in your handling of the fact situation, you then say, well, it would appear from these facts, because of the exclusively terminology, that there was an express provision, and if so, specific performance will lie. All right, let's take a look at question number 16. And we've taken a look, as you'll, and with respect to question number 16, as with respect to question number 4, we've seen it before. The analysis of question number 16 is, of course, the very same as with respect to question number 4. So far, so good. In other words, you mentioned the fact that there's no specific performance of personal service contracts. You mentioned the uniqueness of the services, and you mentioned the fact of what implication the word exclusively means, and how this is necessary to have an express covenant. So far, so good. The reason I discussed number 16 in addition to number 4 is because I expect to see this type of fact situation all by its lonesome self appear on an upcoming bar examination, for the simple reason that there's now been a new decision that's come down on this fairly recently, which took a very interesting twist on an almost identical fact situation. This one involved the B.F. Goodrich Company. Fact situation was very similar to this insofar as B.F. Goodrich had developed a secret process for which was applied in the making of spacesuits. One of the people that was involved in this, intimately involved, and was very well aware of the secret process, then threatened to quit and go to work for a competitor. Okay? Now, there was no express covenant in the contract not to compete. To that extent, it differed. And B.F. Goodrich, where this was raised, the jurisdiction in which this was raised, the same problem was present. There had to be an express covenant not to compete. Absent the express covenant, you were in trouble. B.F. Goodrich, however, prevailed, and they prevailed on the following rationale. That was the fact that the court turned around and said, well, look, this amounts to a trade secret, and we're not going to allow this person to take this trade secret, which he got in a fiduciary relationship, and go to work for a competitor. And you'll note how that could, applying that rationale, that they could work substantial changes on these areas of the law. You should be aware of that decision, that type of reasoning. And if you see a negative covenant situation, a personal services situation, look to see whether or not you have anything that could be construed as a trade secret involved. All right, mutuality of remedy used to be one of the favorites of the bar examiners until Illinois was kind enough to apply some good common sense and change their law. They changed their law by getting rid of all the various negative mutuality doctrines, such as the Frye Doctrine and the Ames Doctrine, that were all predicated on timing factors, and to apply the restatement rule, which is nothing more than good common sense. The restatement rule, simply stated, is that mutuality will be found irrespective of any other facts as long as the court can secure counter-performance to its own satisfaction. Nothing more, nothing less. Let's take a look at question number 28. Number 28. I might mention before we go into analyzing this also that mutuality is of two kinds. The only kind that is at all a viable entity today is that of negative mutuality, and that's what we're talking about when we talk about the restatement rule. Affirmative mutuality, which just that kind of said the reason for granting specific performance is because the other party could have granted it. Well, or could have gotten it. Well, in our situation here, in question number 28, what we have is we have the two miners entering into land sale contracts with C. All right, C seeks to enforce the contract against the first miner. He claims he's a miner and seeks to get out from under. The answer is obviously he's going to prevail. The second situation is a situation now where C seeks to bring a specific, where the miner seeks to bring a specific performance action against C. And C claims, hell, I can't enforce it against him, therefore why should he be able to enforce it against me? And the court, applying the restatement rule, says nonsense. We can secure counter-performance by this miner to our satisfaction. This being the case, we're going to grant specific performance. The facts do not state if C had been able to prove that there was some collusion between the two brothers, he might have gotten out from under both deals. But the facts do not show this, and as such, we can't really rely on it. You might just raise the query. All right, last but not least, in specific performance as anywhere else, and leaving it, you have to get down to discussing the availability of defenses. Once again, we have the equitable defenses, latches, unclean hands. We've discussed them. They're applicable to contractual substantive questions in the same way as to tort questions. Then there are the contract defenses. I mention these here, and once again, they're two obvious words. I mention them here only because the equity questions invariably contain on a regular basis a question that involves a contract defense, and that's usually that of the statute of frauds. The invariable fact situation that often arises in the bar exam, you should be aware of it, is that of where there's a promise to make a testamentary disposition. The general rule on this is that this type of promise will be specifically enforced even though the statute of frauds defense would have otherwise barred it. And that is the rule in Illinois. Remember it comes up all the time. We won't go into any great detail on it. There are questions number 14 and 24 which set out this very fact situation. We don't need to go into them. Those are the questions. They're simply stated. They're easy to get points on. That's the answer. Let's take a look at question number 3, though. Question number 3 is deceptively simple, which is to say that it's really quite difficult. In any analysis of question number 3, and once again, let me just reiterate this because I realize it's late in the summer, but at the risk of overdoing it, I think the point has got to be made that these questions have got to be answered by laying out all the specifics. Thus, for instance, if you're going to talk about this question, the first thing you do is talk about whether or not there's a contract. You mentioned this. There is a contract between the two parties, albeit an oral one. Secondly, have the conditions been fulfilled? We talked about this before. This is necessary for specific performance. All right, in this case, the condition was that Mello would take care of Sophia for the rest of her life. Has she? No, but Sophia was probably to blame for it. So there will probably be a waiver of this condition preceding. All right? Is there a property right involved? Or could she just be compensated by damages? Is the legal remedy adequate? The answer is there is a property right involved, obviously because it deals with land, and the legal remedy is inadequate because we're dealing with land. In answering a question, I'm willing to bet that probably 80% of the students won't analyze it that way, and I can only caution you, just stop before you plunge into an equity question. Learn these little rules. They're easy enough. They arise in all the areas, and be sure to spew them out. Be it rote and mechanic, they're worth points. All right? Now, assuming then that you can get specific performance because all these other things have been met. two further questions. One is you can get specific performance of a contract only under the terms of the contract. And the terms of this contract called for a testamentary disposition. Obviously, in Part A, Mella should not prevail because she cannot get a conveyance now, because that was not the terms of the contract. What she might be able to do is get a constructive trust, sort of thereby stopping Sophia from otherwise selling the land and coming out from under the terms of the contract. Here, once again, we have an oral contract situation. We have a defense that can be raised by Sophia of statute of frauds. The Illinois rule is such that, as a matter of policy, in these situations, the statute of frauds will not act as a valid defense. Situation number B, then, because we now have the situation where the contract could be enforced according to its terms, i.e. testamentary disposition. Situation number B, Mella will prevail and will prevail immediately. All right. Once again, you get 3 to 4 questions in the area of equity in your bar examination. For years, the only areas that the bar examiners took these questions from were those of injunctive relief in tort situations and in specific performance cases. One, as you're all, I'm sure, well aware, and as we've even mentioned here several times today, the bar exam becomes increasingly sophisticated every year. Every year they tend to go further afield to find their questions. Well, where they've gone further afield in the area of equity, and you can count on one of your 3 to 4 questions coming from these areas, they've gone in further into the contractual substantive area, they've gone to equitable conversion, and they've gone to rescission and reformation. Once again, these are fairly easy areas. They can be easily analyzed and laid out in the bar exam. Make sure you know them, though, because you can count on one of your questions coming from these areas. And as a matter of fact, if you get 4 questions, in all probability, there will be one dealing with a tort, one dealing with specific performance, one dealing with rescission and reformation, and one dealing with equitable conversion. All right, equitable conversion, most simply stated as a rule, is at that moment of time where 2 parties enter into a land contract and execute it, so that it's completely executed, their interests change. The vendor winds up with a right to money, i.e. a personal property interest. The vendee winds up with a right to land, i.e. a real property interest. Obviously, this only becomes interesting in limited situations. The main situation, and the one that always arises in the bar examination, is that of inheritance, where the 2 parties come in and the one claims, obviously has the right to the personal property, the other the right to the real property. All right, now if you're going to see it on the bar examination, invariably it's going to come in 2 questions are going to be raised. One is, or 2 facts will be presented. One is it's going to be an inheritance situation, and 2 is, and you can almost invariably count on it, you're going to have an option contract situation. Note the following: the rule is that there is no equitable conversion in Illinois accords until that option is exercised. All right, let's take a look at question number 34. Question number 34, it's the standard equitable conversion question. It involves exactly those elements that I just discussed. Very easy to handle, very easy to get full or near full credit in the bar examination. Once again, you remember, all you really have to do is state the rule of equitable conversion, state who gets what interest, and then talk about whether or not an equitable conversion is worked in where, or the timing in an option situation. Once again, as we've just talked about it, there is no equitable conversion until that option has been exercised. Therefore, in this situation, since the option has not been exercised, the vendor still possesses the real property interest, the vendee still the personal property interest. and the properties will pass accordingly. To see a wrinkle in the situation, let's take a look at question number 30. It's fairly much the same question we've just talked about. The option hadn't been exercised, and the property passes as such. The option, when it is exercised, the benefits then go to the person who has the real property interest, which in this case is the son. The fact that the daughter has received lease proceeds, and that these proceeds are applicable towards the purchase price, will not work to change this result. She still has only a leasehold interest, as you know from your personal property course. That's a personal property interest. One thing you might mention or might note is the fact that she still has a right to the lease proceeds and does not have to refund them to the person with the real property interest. Okay, just before we take our break, you might note there's one other thing. That's the fact that, as I've stated, to date, to the extent equitable conversion questions have appeared, they've appeared in the context of questions 30 and 34. The one other area where it might arise is that of who bears the risk of loss. Now, historically, in the majority view, but not the Illinois rule, has always been that the risk of loss is on the buyer. This was held to be consistent with the fact that the buyer had the real property interest. However, the new rule that is coming in a great number of jurisdictions by statute and is in Illinois, and it's under the Uniform Vendor and Purchaser Risk Act, comes up with a good common sense result, which says that the buyer will have the risk of loss, but only if he has one of two things. He either has to have legal title or possession. If he has neither, the risk of loss resides with the seller. All right, gentlemen, let's take a break. The buyer, they can turn around and they can say, an infant can always get up. All right, gentlemen, let's get rolling. Before we launch into our final part, just a brief announcement. In order to accord with the request of the people that are paying the veterans who don't want this course to end before Thursday, ethics and mortgages have been deferred until a Thursday lecture. Corporations, as scheduled, will take place Wednesday. All right, one point of clarification before we move on to rescission and reformation, and that's just with respect to equitable conversion. Several people asked during the break the question of what happens. You have an option which has not been exercised. Assume a piece of property worth $10,000, and assume that the person that had the buyer had $10,000 in his estate. What happens? Well, what happens is as follows. The $10,000 in the buyer's estate, since the option has not been exercised, go to those people entitled to personal property. The land goes to those people entitled to the real property. Now, the right to exercise the option also goes along to the first estate, and if the people entitled to the $10,000 so wish, that option can be exercised. But at that point in time, what happens is as follows. The land comes over, and the people that were entitled to the personal property that had the $10,000 get the land. And the $10,000 goes, on the other hand, to the other estate, to those people entitled to the real property. All right? The last area, and also one receiving increasing emphasis on recent bar examinations is that of rescission and reformation. Now, a rescission of a contract is basically that state of affairs that arises when there never has been a meeting of the minds. I mean, this is taking your just basic elements of a contract. One, of course, is the meeting of the minds. It's the very first one. Rescission states that there never has been a meeting of the minds, and therefore that contract is voidable ab initio. From the very beginning, that contract was never any good because this element was not present. The parties thought they were bargaining for something else than what they really bargained for. All right, if you think about it in those terms, why don't you have a meeting of the minds? And if you think about it in those, like I say, in those terms, the reasons are obvious enough. One reason you don't have a meeting of the minds is because the parties were mistaken. All right, what type of mistake do you have to have? Well, if there's no meeting of the minds, obviously there's no meeting of the minds if you have a mutual mistake situation. And all courts, including Illinois, will hold if there's mutual mistake, there was no meeting of the minds, and that's a valid grounds to rescind the contract. What about a unilateral mistake? A unilateral mistake, where one party didn't know what was happening, but the other party did, is not sufficient for rescission. Now, you might note that some jurisdictions in recent cases, and this has been pointed up in a fairly recent bar examination question and a set of facts, some courts in a unilateral mistake situation have found grounds for rescission where the party that was mistaken would suffer an undue hardship if this contract were to be enforced. All right, obvious enough, then the second grounds, along with mistake where there's not going to have been a meeting of the minds, is that situation where there has been a misrepresentation. Now, if you see a misrepresentation, ask yourself, the first question you have to ask yourself is, what type of misrepresentation? Was it innocent, where the party that made the false statement didn't know it was false and made it in good faith, or was it willful, fraudulent? If it was an innocent misrepresentation, then the party that's seeking the rescission has to prove that he reasonably relied on this misrepresentation. If it was a fraudulent misrepresentation, all you need show is actual, in fact, reliance. All right? One further caveat. If you answer a rescission question, then your analysis, the first thing you look for is, was there a mistake? If there was a mistake, what type of mistake? Mutual or unilateral? Was there misrepresentation? If so, what type of misrepresentation? Innocent or fraudulent? Next, look to see what was the type of mistake, and it has to be, or pardon me, a misunderstanding. What did it go to? And you've got to get this in any question and any answer. It's got to relate to a material fact. An immaterial fact is not sufficient. There might be an abatement of the purchase price or what have you, but it will not serve as grounds for rescission. So we have a lack of a meeting of the minds with respect to a material fact. That's all we're really talking about. All right, let's take a look at question number 32. What are we talking about in question number 32? We're talking, obviously enough, about rescission. First question is, no meeting of the minds, why? Unilateral mistake. Now, unilateral mistake, as we've just discussed, will not suffice for rescission if the other party knew or should have known that there was a mistake. Now, at that point in time, in answering this question in the bar examination, you have to play around with the facts and talk about whether or not the one party here, the buyer, at least should have known that the other party was acting mistakenly, by virtue of the fact that there was such a great differential in the price of the property, double the price and being the actual value, et cetera, et cetera. That has to be discussed. After that, the next thing you should discuss in wrapping up any analysis is to state the general rule that, assuming that he didn't know or shouldn't reasonably have known, unilateral mistake will not suffice. However, there has been a liberal trend to hold that it will suffice, where it'll work an undue hardship on the mistaken party. We just discussed that. This is the perfect type of situation. Invariably, you're going to get it. It's going to be little old lady type of things. Well, you have it here. And that type of thing should be mentioned for your perfect answer to obtain full credit. Let's take a look at question number 11. Once again, it's another one of the equity giveaways. It's very easy. All you have to do is play around with the facts. Once again, though, you have to set out a couple of your black letter law rules. You talk about rescission. What is rescission? When will rescission be granted? It'll obviously be granted in a case of misrepresentation. Obviously, here you have a case of misrepresentation. The other thing that you have to mention here is whereas under these facts, the misrepresentation would appear to be fraudulent, the only reliance that need be shown is actual reliance. Remember, once again, if it's an innocent misrepresentation, then reasonable reliance must be shown. All right, in a rescission situation, presently, although it used to be different, you don't have to, the one party does not have to make an offer to restore the other party to his status quo position. This is something like the mutuality rule we just talked about. As long as the court can secure satisfactory performance, that'll be fine with it, and that'll be sufficient. So another thing you should also note, and I wouldn't be surprised at all to see this arise in a bar, on the bar. It hasn't to date, but it'd be exactly the type of thing that they would raise, and you'll see it here under defenses. First of all, you might note in defenses that all of your same usual defenses apply, including latches, unclean hands, etc. There's a special defense situation that arises in a rescission of contract situation, and that's the election of remedies. If the party seeking rescission has previously brought a damages action, he cannot now bring a rescission action. The reason being that by virtue of bringing a damages action, which is an action on the contract, he has affirmed the contract and its viability. As such, he is stopped from now claiming that it was voided ab initio. All right? The reverse, however, is not true. If the court holds that the contract should not be rescinded, damages action might lie. Okay, so much for rescission. The second thing we're going to talk about is that area of reformation. Now, reformation's got to be distinguished from rescission. Rescission is the type of situation that takes place, two parties are sitting in an office somewhere, and they bargain for a piece of land that both of them, without having seen, as far as they're concerned, it has a frontage of 200 feet. And they bargain on that basis. Well, afterwards, it's discovered the land only has a frontage of 150 feet. That's an action for rescission. There was no meeting of the minds. They thought they were bargaining for 200 feet. Now let's take the situation. The same two individuals are standing on the sidewalk, and they're looking at the piece of land, and they're saying, yes, this is the piece of land we're going to bargain for. And then they go home and they write the contract and they put down 200 feet, or pardon, they put down 150 feet, but in reality it's 200 feet. Well, they saw the land, they had a meeting of the minds, they weren't talking about figures as such at the time, and this is the ideal situation, or the perfect situation for reformation. All you're doing is you're talking about rewriting a contract so that it conforms with the meeting of the minds. But there has been a meeting of the minds. Rescission, there is no meeting of the minds. All right? The first and most obvious question if you're going to reform a contract is whether or not there's a valid contract in the first instance. Once you found it and you said there is a valid meeting of the minds, there appears to be a valid contract, then you go in to reform it. On what basis would you reform it? Well, obviously, you're going to reform it here, as with rescission, if there's been a mutual mistake situation. But what about a unilateral mistake? Well, here, once again, you will allow, most courts will allow the rewriting of a contract in a unilateral mistake situation. You might note that Illinois has taken a very hard stance on this and will allow it in a unilateral mistake situation only where there is accompanying fraud. Of course, that amounts to more or less almost amounts to misrepresentation, and in any event, you might also note that the Illinois decision is ancient at its best. As such, I'm not sure if they'd hold to it today. You might mention, if you come across the situation on the bar exam, that Illinois has taken a hard stance, but that if it came up today, they would probably tend, as they have in all the other areas, to liberalize their thinking. All right? Obviously, if there's a misrepresentation made, the contract will be reformed to reflect the expressed intent of the parties. Let's take a look at question number 20. Question number 20. You might note that question number 20 also is a question that was misread by well over the majority of the students taking that particular bar examination. As we just talked about, the first question the first thing you have to discuss in a reformation situation is, are we reforming a contract? If so, did a valid contract exist? Well, here, as a starter, we're not talking about a contract. We're talking about a gift. This is where most students misread it. As it turns out, this type of mistake was not that tragic. You lost points for it, but it didn't necessarily mean you weren't going to get a passing grade on it. In any event, the first thing you have to discuss then is the fact that this is not a contract as such, it's a gift, but a gift, since, as you know from your personal property, one of the three main elements of a gift, along with intent and delivery, is acceptance. Therefore, by analogy, the contractual rules of reformation should apply so that the original agreement, be it a gift agreement, between the parties is reformed to reflect the original intent. All right, here obviously if there's going to be reformation, it's going to have to be based on mistake, and you should discuss whether or not the parties were mistaken under these facts. In all probabilities, they should. Or the court should hold that there has been mistake and that this requirement's been met. You might note, incidentally, that this is also, since it is a gift situation, not the type of thing really where laches is an applicable defense, even though there's been a passage of time. Let's take a look at question number 31. Question number 31. Obviously, we're talking about a reformation situation where a valid contract would appear to exist. Remember, this should be sentence number 1 in any answer in the reformation area. All right, the valid contract exists. However, it apparently doesn't reflect the agreed intent, at least of both parties. The one claims that there was a unilateral mistake. All right, unilateral mistake will generally be sufficient in the overwhelming majority of jurisdictions if the other party should have reasonably known of it. Well, here, because of the price discrepancy, it can be argued that the other party should have known. Remember once again that Illinois takes a very hard stance on this, and obviously the other party here had nothing fraudulent about its conduct. You might, however, also mention that Illinois today would probably come up with a different result. Now, there's something else that should be discussed in answering this question, and this is the fact that the one party might argue with respect to reforming this contract, might claim, well, this is a laches situation, and proceed on the following basis. They say, well, look, you're talking about $16.50 now being the fair price, but if we hadn't accepted your offer for $6.50, we might have accepted somebody else's offer for $14.50, and therefore this would work an inequity upon us, and this result cannot obtain. Well, you might note that in a reformation situation, the court would not necessarily have to move the price up to $16.50. They could compromise the issue, let's say, and arrive at a $14.50 price. All right? But laches would have to be shown, would have to be proven or something analogous to it, prove that there was a detrimental effect on it. Let's take a look at question number 22. Question number 22. The first thing you have to do is talk about whether or not it was a valid contract. Then you have to talk about the question of reformation. Now, this obviously is somewhat of a sticky question because your generally applicable grounds for reformation, namely mistake and misrepresentation, are not present here. Still, a fairly valid claim could be made that since both parties had agreed upon one given set of facts, that the contract should be reformed to express the agreed intention of the two parties. Remember, this is agreed intention. The defense, needless to say, can be raised that this is an unclean hand situation. And indeed, remember we talked about this, the unclean hands has to relate to the transaction in question. It obviously does here. You might also note, however, that an equity court might disallow the defense of unclean hands where the person claiming it in turn has unclean hands. There's a hairline decision that could go either way. Those are the relevant factors that have to be discussed. All right, so much for the specifics of equity. Now, a general comment on equity, and this is the fact, and on the bar examination in general. Equity is an area where some of the most surprising questions arise, and questions that are not really equity. Now, you can count on the fact that of your bar examination questions, you're going to have a couple that you just are going to have no idea whatsoever what category they fit into, where they came from, or how in the hell you should answer them. I might mention that to the extent these questions arise, and they arise every time, more often than not, one of them falls within the broad category of equity. Now, I happen to know one bar examiner that, by way of example, and this happens fairly regularly, and usually explains these questions, an equity question of recent years arose in the following way. He had a very sticky question in his own file at the office that more or less related to equity. And the thought struck him how nice it would be to set 1,000 minds to work devising clever solutions for him. And indeed, it wound up on the bar. As I say, you're going to always see 2 or 3 questions like this. Don't panic, because one thing I know for a fact is that the bar examiners tend to be extremely lenient in answering these questions, and all that they require from you is some sort of organization, some sort of analysis whatsoever that shows that you're able to apply some sort of common sense. Once again, equity is very easy. It's marked easily. That's another thing, too. And all you have to do, once again, in studying this thing, is remember to get these little buzzwords straight. Inadequacy of legal remedy, property right, etc. And you shouldn't have any problem. It's a great place to pick up points. Good luck, gentlemen.